Sono d'accordo.
Thank you. I agree. So we can close our discussion on the point for the time being and repeat our thanks to Jane Green, Mrs. Green, for her intervention. And we can now move on to the next item on our agenda, which is the item 10, report on the fact-finding visit to Denmark. Now, for the first of exchange, I'll give the floor to Mrs. Wertmann.
Thank you very much, dear colleagues. You have read the report, I believe. I would like first start with a comment that also to this meeting the ministers and the head of the police had been invited, and it was, according to my information, only the new Minister of Social Affairs who responded back saying that she was unable to attend our today's meeting, and I think she deserves a thank you for that. I would like to start with a technical explanation of a few very important points due to some questions that arose in the past weeks, I have to say. What is our role as a committee of petitions? It is to do research and examination with regard to possible violation of citizens' rights referring to the treaty and in cooperation with the authorities, national ones, regional ones or local ones. So this is exactly actually why a European citizen may submit a petition with the European Parliament. Once the petition is received, the petition is examined by a committee and either it is declared admissible or inadmissible. What are fact-finding visits? Fact-finding visits as this one are done with the authorization of the Parliament's President. So it's an official delegation that we had. And the delegation consists of some members of the Petitions Committee, official members of the Petitions Committee, and these official members of the Petitions Committee appoint a head of the delegation. Usually, I have to say usually because it was not the case in this case, there are accompanying members, so to say ex officio members, who are just there to see and hear what we see and hear. And I think it is also very important for the citizens or for the petitioners to understand that we can only act and react on the information of what has been given to us, on the contents that is relevant to the relevant petition, and that we are by no means judges and the committee is not a court. I think that has to be very clear. And at this point I have to mention, or I would like to mention, that we were approached by one of the counterparts of the petition, of the petitioners, and but the sessions of the committee is usually only open for the petitioners themselves. So what can we do actually? What is our goal here? We, on the one hand, can alert the relevant authorities that there is a problem, or we can also at least bring it to their attention that there is a problem that they have to deal with. I think that is also very clear. When can we do that? Is exactly or especially when we see EU law violated, and this of course includes also the human rights. So concerning our delegation here, should there be no change in the situation, my colleagues and I have already agreed that we certainly continue our work, but I would like to assure you, Madam Chair, that at the point of time we do hope on the cooperation and we do hope on an improvement for the petitioners and for the children. And that brings me exactly to the situation that we have at with these petitions. We have received petitions, and the petitions that had been declared admissible had been discussed in the committee meeting in February. During that meeting already we understood that it is of utmost urgence to go to Denmark and to see and listen ourselves, and because we felt the focus of these petitions is not only the petitioners, the mothers or fathers, some Danish mothers, some non-Danish mothers, but also some non-Danish fathers, but it's the children. And the different forms of alleged abuses of the children. And we took this very serious and decided immediately to do such a fact-finding visit right away, or at that time we said as soon as possible. The petitions deal with points where we understand that the chapters of the Charter of Fundamental Rights are obviously being violated, And this includes, of course, the European Convention of Human Rights, as well as the Universal Declaration of Children's Rights and the Convention of the Protection of Children's Rights. I would like to give a short outline on the structure of the delegation of the fact-finding visit. We also invited, of course, the Minister of Social Affairs, as well as the Minister of Justice and the head of the Danish police. Even though we had rearranged our trip to meet earlier to accommodate these three high-ranking people, none of them was ready to meet with us. The common excuse was we are facing summer recess. We said that it is basically the first time that ministers deny a meeting with a delegation of the European Parliament. And I would like to be allowed to mention that just a few days after our fact-finding visit, I got a note that the Minister of Social Affairs actually preferred to stay in her kitchen yard. And some more days later, the said minister found, though, time to receive a delegation from China. So I would like to say, given the preference of the kitchen yard, and as our French people would say, les carottes sont cuites. It is definitely enough. I have to say that, unfortunately, also the new Minister of Social Affairs keeps quiet, just as the Minister of Justice from the very beginning. And I'm sure we will question also this. Concerning the Minister of Social Affairs, Madame Hekkerup, she knew since 2007 about this problem, and we assume that also the Minister of Justice knows and knew already at that time of this problem, but unfortunately the Minister of Justice doesn't answer, doesn't say anything. I could not make I could not find any comment, and neither could my colleagues. As I pointed already out in our last meeting in July, the meeting we had with at the ministry was attended by some high-ranking officials of the minister's cabinet. We had quite a few questions. The questions certainly these people tried to answer to the best possible, but we all agreed that we would have definitely preferred to talk with the ministers, because in the end we felt that we had to leave with a lot more questions due to their vague answers, which we understand because they are not the ministers, they are just the people who work on the one or the other specific field. So that is an open point. This brings me basically to the situation of the petitioners, and I would like to outline one more time that in our report, Madam Chair, we only mentioned the most important facts. It's like the problem that we found, that we listened to, in a nutshell. We had a meeting with the petitioners that lasted about, I would say, almost more than 4 hours. I'm sure Carlos can remember that. We did not dare to move. We did not dare to say anything. It was heartbreaking, the stories that we had to listen to. There were about 90% of Danish mothers, and the 10% left of the attendees were either non-Danish mothers and some non-Danish fathers. And we understood from the very beginning that the core of the whole problem that we found us confronted with is basically the Parental Responsibility Act that was introduced in 2007, which in our personal view is a good act, a good law, because it assures the child access to both parents, and it assures also both parents the access to the child. But as we understood, the practicability as well as the many issues around this Parental Responsibility Act are basically unacceptable and inhuman for the children and their mothers. As I said before, not only Danish mothers, but also non-Danish mothers and a small group of non-Danish fathers. Let me go a little bit into detail. We have tried, as I said, to outline and to give the most important facts in our report. If a mother wants to protect her child or children from an abusive or violent father, it is not the father who is judged in court. It is the mother who is judged in court for not cooperating with respect to the Parental Responsibility Act. Here is something wrong. If one cannot protect anymore a child who had been abused or violated, and I really urge everyone to think about that. And I remember the answer of one of the officials saying that in some cases it was better to go with an even violent father. And our question here is, just because he is a man or because he is of Danish origin? And even our Danish colleagues stated this summer that there was some kind of discrimination. Let me summarize this, but I have the quote here, so we can check on that. Let me also add to this issue the words of one of the members of the Ombudsman's office on the question whether there is discrimination. There is no discrimination. It is not registered as such. That was the answer of a member of the Danish Ombudsman's office. Concerning the alleged abuse or violence of some father, we need to alert to another fact, that a lot of decisions seem to be done because it is in practice. So these men are simply not judged because it is not in practice, but it seems to be in practice to judge women, mothers, who want to protect their children. In some cases, these mothers are even imprisoned under paragraph 215 on the allegation of child abduction or of having retained the child. That the children suffer, we should not even discuss, because either they stay, as I said before, with the violent father, or they are put in foster homes, and some do not even have a chance anymore to meet or see their own mother, not now and not in the near future, and in one case that was reported to us, not any time anymore. So we have to think about that too. In other cases, where the mother wants to move to a different place, she loses custody over her children simply because the access of the father to the child must be given. Should she really not be able to move just because of that? Why can the father not move to a place where he would be closer to the child? We have often listened to such questions. We would also like to point out paragraph 35 of the Parental Responsibility Act, which basically says that a child can be heard in court if the child wants this. We got to know of cases where the children were heard. Nothing has changed. Nothing. Believe it or not, the father was invited to listen to the child's witness. His answer was that the child was lying, the child would have been put under the pressure of the mother, and that everything was okay. And the child grants him still access to the child, and in most cases, sole custody. In one case, the child did under no circumstances want to go back to the father after such a court meeting, and the child understood that the rights were being severely violated, and the child also understood that it would be forced to go back to the father. So the child ran away. Then we have a group of children who have been, I quote, brought back home to Denmark in the kidnapper's eye. Actually, they were abducted. This is, the basis of this situation is that mothers leave the country in full compliance with the Danish law. The child was regularly noted in the Folkeregister as having moved away from Denmark. The mothers have the sole custody over the child, and then the Danish authorities give retrospectively the custody to the father. declare the contrary, and basically make the way free for an abduction. In one case, even a Danish legal high-ranking expert says that the child should have been given back to his or its habitual residence, since the father should not even have gotten any custody retrospectively, and the mother had left the country legally and had the right to bring the child with her. Another group of mothers should be mentioned. There is a group of mothers, a very small one though, I have to say, that is forcefully medicinized. So we should also think of this group that was reported to us. As I said, to give like an exchange of view, to give like an insight to the report, it can only be the, so to say, highlights. I would also like to briefly mention some conclusions, namely that we see the impact of the Danish custody law seems to be disproportionately hard on mothers. In practice, Danish citizens, in particular fathers, have a strong advantage to custody conflicts, and Danish mothers, as well as non-Danish citizens, feel that they are being discriminated against the Danish authorities. Please keep in mind, may I remind you what a representative of the Danish Ombudsman said. There is no discrimination, it is not registered as such. In particular, this even leads to the rights of the children not being respected, as we have seen. Mothers feel that the current Danish law offers no possibilities to protect their children from abuse by fathers. A mother even risks losing custody of her children because she is going to move. In the cases presented to us, it was only mothers, Danish mothers as well as non-Danish, who have been either threatened with or judged on the grounds of paragraph 215. Let me also share with you that we were made aware of severely criminally relevant cases, and we have handed those over to the Danish prosecution. Colleagues, you have a list of the recommendations that we have drafted. I would like to mention two very important points in our view. We urge Denmark to follow up its own resolutions and confirmations once issued, and thus to fully implement and enforce the Hague Convention on Civil Aspects of International Child Abduction, as well as to fully comply with the Child Protection Convention. And secondly, I would like to stress that we also urgently ask, among others, to review these custody and visitation cases as well as international child abduction cases in order to fully comply with international human rights and the Charter of Fundamental Rights, as well as we ask to review this Parental Responsibility Act in such a way that foreign and Danish citizens are treated equally. I would like to stop here, Madam Chair, because I feel I could talk for a lot longer. I would also like to point out that I have been given a very recent, very up-to-date report. Just today I have received about almost 200 pages of a Danish citizen who asked me to share this with my colleagues of the delegation. I unfortunately did not yet have the time to, but I will do so in the next days. And I'm sure, Madam Chair, we all understand that it is very important that we support these petitioners and their children. Thank you for the moment being.
Thank you, Mrs. Wertmann. The colleagues of the delegation want to take the floor now or after? After. Okay, so first the floor to Mrs. Loop for the Commission.
Excuse me, if we are speaking of human rights or child protection, shouldn't be me answering.
Mrs. Hoffmans?
Thank you, Mr. Chair. I will speak from the point of view of judicial cooperation in civil matters, meaning child abduction cases, granting of custody and access rights. The Commission would like to thank the Petition Committee for its useful initiative and for the suggestions included in the draft report in order to improve the situation of children and parents in Denmark. However, from the point of view of the legal framework, the Commission has to underline once again that Denmark enjoys a particular position with regard to judicial cooperation in civil matters, as by virtue of the Protocol 22 annexed to the treaty, Denmark does not participate to the instrument based on the Title 5, Chapter 3 of the treaty. This means that Denmark is not bound by the EU legislation dealing with child abduction, custody, guardianship, and visiting rights. There is EU legislation on the matter, meaning the regulation Brussels 2A, but we have to be clear on the fact that this regulation only deals with common rules of jurisdiction, recognition, enforcement of decisions regarding child abduction between member states and the exercise of the visiting rights. But the granting of the access rights, the granting of the custody as such, is not dealt by the regulation, but is still in the hands of the member states. In any case, it's true that regulation is really useful to deal, for instance, with child abduction cases. Denmark, like all the other member states of the Union, is a contracting party to the 1980 Convention of Child Abduction and to the 1996 Convention on Child Protection. The 1980 Convention established a system of cooperation between the central authorities in order to facilitate the contacts aiming at reestablishing the status quo of the child which has been unlawfully removed from his or her habitual residence. But we have to be clear on the fact that the Hague system does not entail any supervising authority which could control how the member states implement the convention. It's clear we have the Special Commission in The Hague, which has convened on a regular basis. For instance, we have the Special Commission, two Special Commissions on the 1980 and 1996 Convention on Child Abduction and Child Protection in 2011 and 2012, where all the members of the Hague Conference on Private International Law discussed the issue and trying to find a useful solution. But there is no supervising authority. To be clear, there is no such a thing as the European Court of Justice of the European Union. So this is the weakness of the system, which is linked to the fact that Denmark is not bound by the EU legislation on judicial cooperation in civil matters. So it's clear that there are some problems. And having said that, maybe I will give the floor to my colleagues dealing with human rights specifically. Thank you.
Thank you, Chair. With regard to rights of the child, we review every case very carefully that is brought to our attention to examine whether or not there is any connection to EU law. And we keep all these cases under review. With regard to non-legislative work and exchange of information on rights of the child, We have a member state informal expert group on rights of the child where the of child abductions can and will be discussed in the future. And we also have an annual European Forum on the Rights of the Child, this time in December. And one of the topics to be discussed there is parental child abductions. So we do keep all these issues very closely under review. Thank you.
Thank you. And now, Mrs. Auken.
Ja, tak, fru formand.
Thank you, Madam Chair. First of all, I have to say that I did not state that there's discrimination in the Danish courts. I asked for a study, not just of Denmark, of course, but of all the countries, whether there's a tendency to give preference to the citizens of any state. I have a sense it might happen, but I have a sense that it happens everywhere, and that's why I would like a study of this, because it's very relevant for this committee. But I think it's very wrong to only listen to one party in a divorce case, and let the complaints of one party be presented as if they were facts. Angelika Wertmann, my dear friend and the good partner in our work here, you've said several times today that these were facts, that there was child abuse. No, as it says in the report, it's claims and allegations. And allegations are different from facts. And what I don't understand is that there must be many of us here who have been parties to divorces and know how terrible they can be and how you allege all sorts of things and throw allegations against each other. And I can definitely not blame the Danish authorities that they're not willing to discuss divorce cases as we are discussing them here now. Of course they can't do that, and it would be against all good practice in administration if you only listen to one party. There's the Austrian case and the Oliver case, which is a very unfortunate case. But as it's stated in the report, there is a Danish court ruling which gives custody to the father. That's not mentioned in the report, but that's the reason why the Danish authorities say this is not an abduction. I'm not saying who's right. I'm just saying that there is a Danish court ruling from 2010. Now, the Austrian authorities disagree. I know that. I know that an Austrian court has made a different ruling. But I think we are not in a position here to decide which court is right. It's a very unfortunate matter, but I don't think we should throw ourselves into how allegations are made in divorce cases. And in Denmark, fathers don't have better rights than mothers. They're probably better than in many other EU member states, but that's a fact I'm proud of. I'm proud that fathers have better rights, but they're not better rights than the mothers, I promise you that, and I've been close to very many cases, both as a minister of the cloth and in the group of people I meet. And it's just a grotesque thing to say that fathers are in a better position than mothers in Denmark. But as far as I've been able to see in this matter, the Danish government has tried to answer questions through our representation here in Brussels. The answers are maybe not complete, but they really have tried to give the answers. And I don't think that the Danish authorities could have gone into specific cases, especially custody cases. Of course, I agree with the recommendations regarding the Hague Convention and all other to be complied with fully in Denmark, of course, as in any other country. And if it can be proven that the conventions are not enforced, then I think something should be done. I also have to state that I think it's very unfortunate that we have a Danish opt-out when it comes to justice and home affairs, and I'm working to abolish that opt-out. I can tell you, after we got common EU legislation on custody matters, we tried to get a parallel agreement, but that was not possible, or we were refused such a parallel agreement in civil law. We have the same thing in the matter of bankruptcies. We were also denied a parallel agreement. And I won't blame the other EU member states for not granting us this parallel agreement, because I know it's a great hassle. But we did ask for a parallel agreement, but we didn't get it in custody and divorce cases. And I'm very sorry about that, because it does affect children and mothers and fathers, and they're always quite terrible cases. But I would very much ask for that study I mentioned in the beginning, whether we can see, so to study the court rulings in our member states to see whether there's any kind of bias. But saying that Denmark, unlike other countries, would discriminate, I didn't say that, and I can't know whether that's the case.
Collega Iturgaiz.
Mr. Iturgaiz.
Mi querida Margaret.
Dear Margaret, are you listening? Dear Margaret, I don't know whether we've got to do the report or not. I don't think there's any problem in having a report, but don't be mistaken. It's not happening everywhere. It's just happening in Denmark, and that's why we're seeing those petitions coming from Denmark, because otherwise they'd come from elsewhere. And this large quantity of petitions are coming from Denmark, and we went to Denmark because they're coming from your country. Now, I agree with one thing that you have said. You've only seen part of this. You've only heard one aspect, or you've only heard one side of the story. It's like divorces, you've got to listen to both sides of the story. But dear Margareta Auken, you, Madam Auken, you had the opportunity to come. You had the opportunity to be there in Copenhagen. You had the chance to see the way in which the authorities dealt with us, and you nor anyone from your team, no one that you wanted to send came with us. And I would have been delighted if you would have come along with us, because you would have been able to resolve a lot of issues. You would have been able to deal with things in a different way in your country. But you've only heard one side of the story. You're accusing us of that, but we've heard a lot of things. And we never have given such time as in this case to the petitioners, and also the authorities like the ombudsman in your country, and they recognise that that's the way the law is. And it's a bit like lentils, as we say in our country. If you like them, is take it or leave it. If you like them, you eat them. If you don't, you don't. But we otherwise don't have to get involved in the problems or the laws of Denmark. But this is what Danish authorities said to these ladies and gentlemen that came along with us on this visit. So it's not the law that's better for fathers compared with mothers, but we're talking about Danish fathers or Danish, or rather we're talking about, for instance, mothers from Norway, from America, from Italy, from Hong Kong, from all over, different countries. And it's not just setting fathers against mothers. We've got different nationalities for fathers as well. It would be the same problem if it was a Danish mother that was stopping an Icelandic, and Norwegian or Chinese father from from going with their children and the problems that we've seen, the situations that Madam Bettman was describing just now. Therefore, President, I think that this is a report. So this is a report on the fact-finding visit to Denmark. I think we'll have more opportunities to look at this. There'll be a series of issues to vote on at the given time. But in the meantime, I think that we can't say the case is closed. We're far from that. And I've been talking to colleagues. I don't know if Madam Auken would also be willing to invite the colleagues from Denmark here, to bring them to Brussels. We could really have that exchange again, that exchange of views with them, with all of you here, with all of the members of the Petitions Committee, because we can see where we are in this case. After all that information, we know a great deal more. We know all the details, and I think it would be a very positive step to invite the Danish authorities to come here together with the petitioners. Thank you very much.
Grazie, Turgais Jar.
Peter Jahr.
Vielen Dank, Frau Vorsitzende. Das ist schon von meinen Vorrednern.
Chair, thank you. Now, as has already been said, we organised this fact-finding visit because we received a whole series of petitions which moved us, and we wanted to investigate them. This isn't an accusation against you, Margaret. I'm talking generally, so this isn't against you. But I was very surprised by what we saw and the way we received. Usually when we go on fact-finding visits, then we have the opportunity to talk with many of our colleagues, many MPs, and unfortunately we weren't able to do this on this occasion. There were no Danish colleagues available to explain the situation to us, and I regret that greatly. We were treated very kindly, but I think this was, you could call it a friendly neglect on the part of the Danish, our Danish counterparts. There was no real understanding of what was going on. It was the same when we met the authorities. Denmark is very convinced by their legislation, and they can't be persuaded otherwise. We've got problems here with language as well. We can only report here what we were told on the visit. This is our duty to do so, to report what we heard, and what we heard was painful. And so the first conclusions which we have, as have already been said, mean that the questions which we have must be answered by the Danish authorities. This also relates to points relating to criminal investigations that we have asked for information from the State Prosecutor's Office, and we have proceeded the way we have precisely because we are not a court. Now, we have the same problems in Germany. We've visited the German Jugendamt. All these legislative issues, legal problems are extremely complicated. But the issue which we are dealing with here is if Denmark is so convinced by its legislation, if it considers that this is the best legislation in the world for protecting children's rights, I cannot understand why this opt-out still is in place. We are seeing development within the European Union. European citizens are developing a feeling of security. We are developing European legislation, and we are seeing the problems which we're having with Denmark. We've got this tragic petition from Austria. We simply can't continue like this. It's simply completely unacceptable. We can't carry on constructing the European Union in this way. We had a similar case from Italy, and there we saw it worked. Now, if people have arguments, well, this happens, this is the way it is, but we have to cooperate with one another. The cooperation has to take place between the member states, between Germany and Italy, for example. In the other case, this worked, and we were able to resolve this issue in line with the law. but Copenhagen doesn't want to hear anything about that. They're simply pulling down the shutters, saying this has got nothing to do with us. They just, we're just hearing this has gone in front of the court has taken its decision, and that's the way it is. We can't carry on like this. And we've got the problem with the opt-out. Yes, we have to do something about this. It's simply not appropriate for the modern times. Now, the hearing which we organised, that was very interesting. It would have been interesting to have Danish colleagues present there. It was really an experience which made a great impact on me. And we heard about a very tragic case. We had a discussion with the youth judge, and who said that, of course, the protection of the child's welfare is the focus of our work, but there is this new cooperation responsibility between the two parents, that the two partners have to cooperate for the benefit of the child, and this is the heart of the conflict. This is where the real problem is, at least when you've got a Danish couple. So it's stated that they both have to cooperate. That's very good in theory. You've got the mother and the father there. They are both responsible for the child. They should cooperate with one another. This can only be the very best for the child if they do this. That's a theory. But in reality, you've got a different situation. If you've got previous cases, violence in the marriage, for example, violence against the child, which has led to a divorce, it's really very difficult for the two partners to cooperate with one another. How's that supposed to work out? How are they supposed to organise this? And then you've got a situation where one's the goodie and one's the baddie, if you like. How are they supposed to cooperate with one another? You've got one partner who's saying, well, look at what he or she did in the past. How can I trust him or her with the child? So they can't cooperate with one another, and then the whole legislation is completely undermined. And then the second point, it's often said that if two people love one another, they will end up hating one another in the end. And this has led to some very strange cases with children being divided up between two parents twice or 3 times a week. And you've got a situation, if one of the parent wants to go on holiday for 3 weeks, he has to ask the other parent for permission. If the parent lives abroad in the United States, for example, then the situation gets even more complicated. And so you've got a situation where parents who are not Danish citizens are stuck in the country. They can't leave because of this Parental Responsibility Act. So you can see that the system isn't working. And what I would have liked to have seen, that we could have got the feeling from the Danish authorities and from those people we spoke to, that the Danish legislation, the Parental Responsibility Act, isn't working as well as it could do. But we really were just met by a wall, and say friendly. We were ignored in a friendly way, I would say. We came and said that we wanted to talk about individual cases. We were told that we don't want to discuss individual cases, so we really were not really communicating very well with one another, and we weren't able to move forward. And as has already been said, our expectation is now that we should get answers to our questions from the authorities, and we also expect that they have the time and show the courage to come and address the Petitions Committee. Thank you.
Mrs. Wertmann for the last word.
Yes, thank you very much. I will conclude, and I will be very brief in my conclusions. I would just address to the Commission, to the representatives of the Commission, the remark that I wish that they would take a standpoint or a point of view with regard to the human rights situation of the individual petitioners, because I believe every one of us knows about the Brussels 2A, knows about these exceptions concerning Denmark. I would like to thank Peter for his clear review once more, I have to say. I would like to summarize once more that we can only act and react on what the petitioners have given to us. And we can only write in this report what we have heard, what we have seen, what we have learned. It's not about our opinion. I think that is very clear, especially for the one or the other colleague, because I don't think that we should be asked about what we think or how we feel about this. Statistics. Yes, it would be a good idea to have statistics, colleagues. But I believe that there cannot be made any statistics because discrimination is not registered as such. Remember this. There is a problem. There is no material, obviously. You mentioned that you didn't say anything like this. I quote that there was some truth to the claim that Danish judges preferred to grant custody to Danish parents, quote end. Another quote, I think it is true that Danish courts are biased in favor of granting custody to the Danish parent in a Danish foreign marriage or controlled, etc. I think the judges have the attitude that it is best for a child to grow up in Denmark. Quote end. So this is just to help your memory a little bit. Forgive me, but I'm not stupid. I can remember what someone says. And last but not least, you mentioned the Austrian case. Oliver's parents were never married to begin with. And then I want to remind you of the judge's statement on the 21st of December in 2012, Madam Chair, where one of the two judges, and there was a third person, who was simply, I don't know how to express that in English, but this person was basically asked to come and sit there at the sitting. And there was one judge who is a human rights expert, and I refer, when I talk about that this child was abducted, also in the Danish eyes, I refer to this statement, because he is a high-ranking Danish legal expert on human rights. And please let me conclude that what Carlos Iturgaiz said, that we want an official hearing with representatives, with ministers and the petitioners here in Brussels to finally understand what is going on and to finally try to make everything better for the petitioners and especially for the children. Thank you very much.
Thank you, Mrs. Wertmann. Yes, but this is the first exchange. We have to
please just have to, at least to add, whatever Angelica says or not, it was not end of quote. I continued by saying, I guess this is the case in all countries. And that's why, yes, I did.
That's not what is called.
No, it's
yes,
not
okay,
what you
Angelica.
have. Please, and I have called for statistics on that, and we can't find it because you can see how the courts are coming out. And no, but
okay, thank you.
But just
we
make
can,
sure.
We can
of
try
course,
to
I would never say it was
something.
only Denmark who had this. Of course not.
No,
but Angelica,
stop, please,
and please, and then one thing more.
Angelica
is not.
I thank you very much for your debate, for your interventions, and we will invite again the Danish authorities to try to have an open debate with the other parts. For the moment, I think we have nothing else to add. Thank you very much to you all. Abbiamo chiuso I lavori di oggi perché
This concludes our agenda for today, this part of the meeting.